Right. Good afternoon, everyone, and welcome to another Friday lecture in the Lauterbach Center. My name is Hardo van Asselt, and I'm Professor of Climate Law at the Department of Land Economy, as well as a fellow here at the center. And I'm also very privileged and I'm happy that I can be sharing and moderating this session today, which will be include a seminar, a lecture provided by Dr. Penelope Ridings, who's sitting next to me here. And Dr. Ridings is a foremost expert. She is a member of the International Law Commission. She is also a barrister in New Zealand and has had a very long and impressive career, among others, with the Ministry of Foreign Affairs and Trade in New Zealand, as well in many other roles. But most importantly, for today's purposes, for the purposes of the lecture, Dr. Ridings is also within the International Law Commission, the special rapporteur on the topic of due diligence, which, of course, for those of us who have been following the activities of the International Court of Justice recently, is a topic of particular interest. But as Dr. Ridings will tell us today and show us today, due diligence is, of course, a concept with a very long history and also a concept that has been used in all kinds of areas of international law. So as you will give us an overview and talk about the old way of looking at due diligence, the new way, but also the bridge in between and how due diligence has been evolving over time. So Penelope, if I may, you have about 35, 40 minutes to talk, and then we'll have Q&A with the audience, and I look forward to the discussions.
Thank you very much, Professor Van Asselt. It's a real pleasure being here at the Lauterbach Center. This is my very first visit to Cambridge and my very first visit to the Lauterbach Center. Now, I have always aspired to come here, but I have never managed to achieve it until now. So it's my real privilege to be here and to talk to you about due diligence in international law. So just to give a little bit of background, I'm the special rapporteur for the due diligence in international law topic. I'm at the very beginning of the topic, and so I will be preparing a first report, which is very much a scoping report, a mapping exercise. And I'm using this and other opportunities to talk with people to get views as input into my first report. So as part of this, I want to have a look at why due diligence is a topic of interest, not only to me, but to so many other people. It's been a concept that has recurred over 150 years now, and it has occurred in multiple areas of international law. It's very much central and has become central to issues concerning risk and prevention of harm and the regulation of risk, not only to the environment, but also other risks. As we've seen in the advisory opinions on climate change, the 3 advisory opinions, it's increasingly being relied upon by the international courts and tribunals. But to some degree, there's a lack of clarity on some of the precepts of due diligence, and that is what the topic I hope to progress during my time in the International Law Commission. In addressing the topic of due diligence, because it is so both historically important, but also a cross-cutting nature across different fields of international law, I've had to think about how to divide up both chronologically and thematically the topic of due diligence. So I've divided it into 3 time periods, and this is what I call the old path, the new path, and then the bridge in between, but we will see on that aspect towards the end. So the old path is very much the antecedents of due diligence date back to the 1871 Treaty of Washington and the Alabama Claims Arbitration. The importance of this is that the Treaty of Washington was an agreement between the UK and the US on the expectations of neutrals, including that they not support the arming and building of ships to be used against belligerents when they were a neutral. So the question in the Alabama claims arbitration was what was the meaning of due diligence. And there was two different approaches. The UK, on the one hand, saying having a fairly narrow construction, and the United States having a broader construction of due diligence. And so in the end, the tribunal found in favor generally of the position of the United States that due diligence required action in proportion to the risk of harm. And so that has still been an element of due diligence throughout the history. The second area in which due diligence came in was in the area of protection of foreigners and their property. Now, this was at the time again in the late 19th century and the late 18th and through until the early 20th century, where there was a number of countries, particularly in Western countries, that were trying to address the protection of their foreigners and other countries. And this led to a number of mixed claims commissions which addressed the issue of due diligence and the kinds of actions that should be taken to ensure not only to prevent harm against foreigners and property, but also if a harm to investigate and to sanction those responsible. So there's a large number of cases, judicial decisions through this time, and they generally seem to come up with a number of common elements, which I'll come to. But the third area, which is perhaps one of the most interesting areas, is in terms of balancing rights of territorial sovereigns. So here we have a number of cases. So, for example, the Island of Bahamas case, where it made quite clear that the corollary of territorial sovereignty is the obligation to protect within the territory the rights of other states. So this was sort of the forerunner of the protection of foreigners issue. Trail smelter arbitration between the United States and Canada addressed the issue of pollution from a smelter in Canada, which was affecting the farms and economic viability of farmland in the United States. So this was back in 1935, and the trail smelter arbitration looked at a number of different cases, not just tort law in both the common law system in Canada and the United States, but also they looked at a number of cases which dealt with sovereign or quasi-sovereign relationships. And so they came up with the dicta that no state has the right to use or permit the use of its territory in such a manner as injury in or to the territory of another or the property or business therein. So this case was the forerunner to what is called the no harm principle. And it was also the forerunner to the Corfu Channel case, where the issue dealt with the mining of the area in Albanian territorial waters and the effect that that had on the right to innocent passage of UK vessels. And the International Court of Justice, in its very first decision, came out with a very clear enunciation that every state has an obligation not to knowingly allow its territory to be used for acts contrary to the rights of other states. So this was something that we will hear more about, particularly in the third period that I will deal with. But in terms of what the general view of what due diligence kind of meant over this period, the first period, and there's a lot of similarities both in the Alabama claims arbitration, the protection of foreigners, and in the balancing the rights of different territorial sovereigns, is that the first one was that it's not just the failure to prevent harm, but it's also the failure to investigate or punish perpetrators. That a state should have the necessary legislative and administrative system in order to ensure the prevention, but also to use it effectively. And that it was variable to some extent depending upon the means and capabilities of the states. So, for example, there were some cases where some damage occurred to property or deaths to foreigners in very remote areas where beyond the kind of capacity of the state to take any action to prevent that harm. So no liability arose from the prevention aspect, but liability did arise from the failure to investigate and punish the perpetrators. It was also linked very much to possibility and knowledge. So, for example, in the Alabama claims arbitration, there was notification by the US to the UK of the fact that these ships were being built in UK ports. So the UK was notified of this, but didn't do anything because it didn't have the legislative means in which to be able to take action. And the final area is that the degree of due diligence that has to be exercised is a reasonable degree. So it's a reasonable standard came in. So one of the other things which is really interesting about this period as well is that it's very closely related to negligence or fault. And this isn't due to the sort of the tort law, the sort of negligence that was happening at the same time as this. And so it was focused on negligence fault. So that really changed in particular with the new road. One of the significant changes was the work of the International Law Commission on State Responsibility. So in the early years, the various special rapporteurs tried to bring in a negligence and fault area into the rules of state responsibility. But in the time of Roberto Argo, he drew a distinction between primary obligations and obligations of conduct and obligations of prevention. He also drew a distinction between primary obligations and secondary obligations. And primary obligations were the ones where the breaches of international law could occur, but the secondary obligations were the rules on state responsibility. But as a result of his categorization for obligations of conduct and result, the idea of due diligence came to be incorporated into obligations of conduct. But at the same time, there was a lot of discussion as to how this would be operationalized in practice. And there was a concern that this was a way in which to bring in negligence and fault. And the concern that by doing so, this was not the appropriate approach, because there was a feeling that negligence and fault should not lie with secondary obligations, that there should be a place for the primary obligations. So what happened in the end was James Crawford, in his, as when he became Special Rapporteur in 1999, abandoned Roberto Argo's distinction between obligations of result, obligations of conduct, and obligations of prevention. So in that way, the idea of negligence and fault and due diligence was therefore not included in the draft articles on state responsibility, which he developed at second reading. What was interesting about this, though, is that there was a lot of discussion as to whether this should be included among the members of the International Law Commission. And as a result, after this discussion, James Crawford, in vigorous defense of his position, said, if you wish me to include this aspect, due diligence, it will take another 5 years to conclude state responsibility. So, in other words, it was left to one side and not addressed. In this new period as well, there was a codification of the international law and treaty, a lot more treaties, which established various obligations. It consolidated the idea of due diligence in various existing fields of law. So protection of foreigners, that morphed into the protection under an international investment law, full protection and security. In terms of protection of foreigners and diplomatic personnel, it transformed into the Vienna Convention on Diplomatic Relations, Vienna Convention on Consular Relations, And it also developed in international humanitarian law, international law of the sea, and international environmental law, most importantly. So in this way, in this new road, it expanded into different areas. So in international environmental law in particular, it was came to be associated with the principle of prevention and the principle not to cause transboundary harm, significant transboundary harm to the environment of other states or to areas beyond national jurisdiction. This led to the Principle 21 in the Stockholm Declaration, which was then followed in fairly identical terms in Principle 2 of the Rio Declaration. So that even though that there is the sovereign right to exploit your resources, you must nevertheless ensure and have the responsibility to ensure that activities within your jurisdiction or control do not cause environmental harm, significant environmental harm to other states or areas of jurisdiction. In the Nuclear Weapons Advisory Opinion, this was regarded as being central to the corpus of international environmental law. And then it was followed in the Pulp Mills case, Pulp Mills on the River Uruguay, which gave the idea of due diligence a little more meat, saying that you need to use all the means at your disposal to avoid activities that take place within your jurisdiction, within your territory, that cause significant harm to the environment. So in this way, the principle of prevention, which grew from Trail Smelter and Corfu Channel, came to be its own principle of international law and was the subject of the draft articles, which became articles on the prevention of transboundary harm, work which was also undertaken by the International Law Commission and concluded at the same time as the articles on state responsibility. So it also occurred in the international human rights area, where there was a shift from state into state sort of obligations and concerns to individual-centered obligations. And the basic human rights, of course, is to prevent, investigate, punish, and remedy. And it was used to address the acts of private parties. There's many cases across in this field of international law, which deal with either explicitly or implicitly with due diligence. And I've mentioned just here one, the Osman in the United Kingdom, that where a state knows or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual, resulting from criminal acts of individuals, then if they fail to take the measures within the scope of their powers, judged reasonably, then they might be expected to incur responsibility for failing to avoid that risk. There's also a heightened standard of due diligence expected of vulnerable groups. This includes women and children subject to domestic violence. It also includes a most recent case, which was the Center of Human Rights in Tanzania, and in respect of people with albinism in Tanzania. So in that way, very vulnerable groups were those to whom a heightened standard of due diligence was required. In the other fields that it addressed, it looked at came into international humanitarian law, particularly because of the obligation in Common Article 1 to respect and ensure respect for international humanitarian law. It came up in the law of the sea as well, in particular through two advisory opinions from first the Seabed Disputes Chamber of the International Tribunal for the Law of the Sea, and that was in the responsibility for the area advisory opinion, and then in the tribunal itself in the Sub-Regional Fisheries Commission advisory opinion. So these advisory opinions, in a nutshell, used due diligence as a way in which to ensure that there was not an accountability gap, because in the Law of the Sea Convention, much of the obligations on a state cannot be filled without the engagement and the action of third parties. So, for example, in the case of the area opinion, it was the contractors of the sponsoring state who were the ones who actually undertake the various activities to ensure the obligations are met. In the case of the Sub-Regional Fisheries Commission, it's a situation of flag vessels, fishing vessels, which fish in the waters of another state, and is ensuring that those flag vessels comply with the rules and regulations of that coastal state. Also, it applies more broadly to the responsibility of flag vessels to ensure that the administrative arrangements that take place on the vessels ensure that they are by the state concerned. It also came up, as I mentioned, in investment, lawful protection and security as an offshoot from the original old path. So you'll see from these common features in what I call the new path, very similarities with the old path. It was regarded, and this came through particularly in the scholarship, I would say, that discussed due diligence at this time. It was due diligence was regarded as a standard of conduct attached to a primary obligation, that it was a flexible standard, that you used your best efforts, the state could use its best efforts, and it was a very variable standard depending on the circumstances. It required an in concreto assessment of the state's conduct, but in light of its means and circumstances and its capabilities. There was a knowledge element, and particularly the foreseeability of harm and risk, but there was also a standard of reasonableness. And then the final area is there was a proceduralization of due diligence. So if you recall the Alabama claim, it was the failure to notify, the fact that they had notified but failure to act on the notification. In the Corfu Channel, it was the failure to notify of the danger of the potential for mines in the territorial sea of Albania. And so notification, consultation, and the environment area, the need to undertake an environmental risk assessment. So these were sort of the procedural obligations that were attached to due diligence. So the idea being, according to some scholars, that if you comply with your procedural obligations, you therefore met your due diligence obligations. So the bridge. Now, this is where I start to get a little bit more potentially controversial. So in the third time period, which I've concentrated here on the International Court of Justice advisory opinion on the responsibilities of states in respect of climate change. But at the same time, there was the whole issue of accountability, and accountability gaps started to get increasing attention in the cyber space. So in the context of the application of international law to cyberspace, states started to set out their national positions on cyberspace. And many referred to the Corfu Channel original sort of idea that states should not knowingly permit their territory to be used for acts contrary to the rights of other states. So this was picked up by a number of states, and this includes not only those in Europe, but also those, for example, in Asia, Korea, Thailand, also in Latin America. It was also picked up by the African Union. So it started to be a broader harking back, can I say, to the Corfu Channel. This happened even further in the pleadings before the International Court of Justice, the advisory opinion on climate change. So there are a number of states who expressed the view that there was a broader principle of international law along the lines of the Corfu Channel. Some called it a principle, some called it a duty, some called it an obligation. But it had a central thesis that you should not knowingly allow your territory to be used for acts contrary to the rights of other states. So the International Court of Justice did pick this up because on the one hand, there were those states which saying they were this, and on the other hand, there were these states and many states saying that due diligence was a standard of conduct attached to a primary obligation. So the standard kind of the new path, the middle path. The International Court of Justice picked up on both these things. They made it quite clear that due diligence is a standard of conduct whose content and specific situation derives from various elements, including circumstances of the state concerned, which they evolve over time. So that was very much the standard of conduct approach. So I had seen some scholarship saying that this means that the old was out of the window. That was only really the standard of conduct aspect of due diligence. However, I picked up this particular sentence, and there's only one sentence in the entire advisory opinion, and it was a affirmation of what most participants are saying, according to the court, that the duty of prevention of transboundary environmental harm is applicable to climate change, relying on the general nature of the no harm principle from which the court derived the duty to prevent significant harm to the environment. So if you remember the Pulp Mills case, that drew upon the Corfu Channel in order to derive the principle of prevention. So the court was basically indicating that there is, I submit that the court was saying that there is this broader principle from which the principle of prevention of environmental harm is derived. Now, the next sentence after the sentence, in paragraph 133, then talks about sort of climate change, the other side of the story. And the other side of the story, of course, is that there was those states who did not consider that the prevention of transboundary harm applied to climate change. So there is an argument that could be made that this was really dealing with the lex specialis, and that this really should not be read out of context. So, in terms of coming back to what the court did say about due diligence as a standard of conduct, they talked about due diligence as stringent standard. And in this, they used the word stringent, which was used in the advisory opinion of the International Tribunal for the Law of the Sea on climate change. The word heightened was used in the Inter-American Court of Human Rights advisory opinion on climate change. So, in other words, the stringency is an element to the issue of due diligence. The court also said that the threshold is variable. This is consistent with what they had said before, but it can be heightened due to the risk and the scientific knowledge about harmful impacts, and also the urgency of the issue. And so both the Tribunal for the Law of the Sea and also the International Court of Justice made it quite clear that there were, in the case of climate change, the risk as established by scientific evidence was real, and it involved significant harm, long-term harm, and there was urgent need for action. They also quite clearly said that the standard can be a restriction on the discretion of states. Now, this came up in part because of, I won't address that here, but in part because of the idea that the nationally determined contributions, the NDCs, are up to the state's discretion to determine. And the court looked at this and indicated that it wasn't simply the requirement to establish a NDC, but it was the content of the NDC that also mattered. And they used due diligence and interpretive approach at the content of the NDCs. They also said it was following earlier case law, the Bosnia genocide case. They said it needed in concreto assessment, taking into account various factors. And these various factors for means and capabilities, but also common but differentiated responsibilities and respective capabilities. And in terms of complying with a standard of conduct, efforts must be required lead to the result intended to achieve the objective. So in the case of the nationally determined contributions, this was the 1.5 degree target, but also the ensuring that the total level of greenhouse gas emissions was controlled. So the question that I have, and the question which is an important question to address in a topic such as due diligence, is whether there is a general obligation not to cause harm to the rights of other states, from which the principle of prevention flows. If there is such a general obligation not to cause harm, then it is potentially quite cross-cutting. So that is one sort of potential avenue, or it shouldn't just be a very context-specific attached to a standard of conduct attached to a particular primary obligation. On the one hand, there are states saying, yes, there is a general obligation, and there's a number of states saying that there's a general obligation. On the other hand, there's particular states saying, no, there's not categorically, and that it's only a standard of conduct applied to a particular obligation, and it gets its context from that particular obligation. So you only look at that obligation, nothing more broader. If you would take the first approach, of course, it has quite far-reaching consequences. It comes down to, in a sense, on one hand, a risk of overgeneralizing with potentially unintended consequences, or on the other hand, the risk of fragmentation, so that there's no commonality of due diligence across different fields of international law. So I'm right at this middle conundrum right now as to what should be done about due diligence in this regard. So my question is there a good emergence as a result of the advisory opinion on climate change, emergence of the old path and the new path? Or is there no bridge, as they're just simply different paths, and they would be retained different paths, the old path and then the new modern path and its application? So as part of why this matters, obviously the principle of prevention is very much to the fore in environmental protection and climate change. But we've also seen the similar articulation of it in the Corfu Channel case, in cyberspace, in the context of cyberspace, but also potentially in the context of emerging technologies as well. We've also seen it in human rights and transnational corporations. There's a lot of work being done in the Human Rights Council and Open and Working Group on Transnational Corporations, which is looking at, amongst other things, whether there is a responsibility on states to ensure that transnational corporations don't cause human rights violations when they undertake business operations in other countries. Now, this is quite controversial at the moment, but there are some states who are saying there is such an obligation, and there are other states saying that it's not such an obligation. So this means that it's of great relevance to, I would say, both domestic courts, but also international courts and tribunals. And it really is being used as potentially to fill an accountability gap. And because, as you will know, under the rules of state responsibility, the conduct of private parties is not attributable to the state. But if it doesn't leave it there, then there's a lot of activities that take place that there would be no accountability for under international law. You need to rely upon domestic law, and then that's poses real problems and issues with regard to jurisdiction. So there is a view that there is that this is a way in which to address the impact of the articles on state responsibility and the requirement under them that the conduct of private parties is not attributed to a state. So it is a way in which to address the conduct of private parties, particularly business and transnational corporation, but also individuals. But it does raise very important questions. The thing as a special rapporteur, which is what I need to do, is that I need to look very closely at the practice of states. So the practice of states can be determined through various means. In a context like this, the kinds of state documents are a wonderful resource, but it's often very difficult nowadays to find the requisite protest notes and such as state documents. So pleadings of states before international courts and tribunals is very important. But also the views of states when they respond to this report. So for that reason, I am going to be asking a number of questions in order to try to get clarity on some of these issues. And the questions that I will be asking, particularly on the scope of what this topic of due diligence should be covering. And it's the scope that will address this significant issue as to whether there was a general obligation broadly to not cause harm, I put it more generally like that, or if there was just simply a specific obligation attached to a primary obligation in which you can exercise due diligence. So the other aspect to this, and this is what is very unclear in a lot of pleadings and the views of states, is that the idea of not causing harm to the rights of other states is based essentially on sovereignty. So in a global world where you need to cooperate with others, you cannot be from an island, but you cannot be in an island on your own. You need to cooperate with other states. And that the idea of an no harm rule would enable cooperation between states, so that it is based upon sovereignty, the need for cooperation, but also other principles such as the principle of non-interference and non-intervention and inviolability. So that is the sort of the harking back to the old approach, and is very much coming through in the pleadings. So we are, I think, at a crossroads. I don't think this is going to be resolved quickly. The topic nowadays for the International Law Commission takes about 5 years. So that is my sort of plan if I'm re-elected onto the International Law Commission, is about a 5 year to 7 year plan. It does also require a degree of prudence and careful navigation to make sure that if there is an old path and a new path, that if the bridge between them has to be very carefully navigated. So I will end there and open the floor for discussions, if I may.
Sure, it's